Welcome to today's presentation on title examination, running the chain of title. This is a very important lesson that I teach in the professional land management course. I've kind of modified it for the Division Order Certificate program. But this is a critical skill that a landman has to have. And the whole purpose is to go back to the county records to figure out who the current mineral owner is. And once they know the name of that current mineral owner, they can go ahead and then lease from that mineral owner. So you remember last week when we were talking about real property, every instrument has to be recorded and to be binding against third parties. So if you fail to record it in a timely manner and someone else takes a lease from that person and they record it, their rights trump our rights. So it's very important that landmen understand how this chain of title works and how the recording process is and how critical the recording process is. Okay, but I thought I'd begin with a joke today to honor my Cajun heritage, and I'm going to go ahead and do it with the accent. Boudreaux was so excited he bought a 40-acre plot of land in Louisiana. And he said, I'm going to start a ranch over here. And man, he thought he was something else. Man, he thought 40 acres, man, I got more land than anybody. And so he said, well, I'm going to celebrate. And he decided he was going to go to Houston, Texas, and go to this fancy hotel called the Houstonian. Now, for those of you that are not from Houston, the Houstonian is where all the movie stars stay when they come to Houston. That's where Madonna stayed. That's where Michael Jackson stayed. That's where, all those kind of famous people. Bill Cosby, I believe he stayed there. So that's a very prestigious hotel in Houston. So Boudreaux thinks he's something else, and man, he signs in and he goes and he puts his clothes away, and then he says, well, I think I'm gonna put my bathing suit on and I'm gonna go to the hot tub. So, man, he goes down to the hot tub, and there's only one guy in the hot tub. And he says, my name is Boudreaux. I'm so happy for you to meet me. And the other guy says, well, hello, my name is Dick Clayburg. Now, for those of you that don't know, Dick Clayburg is the owner of the King Ranch. The King Ranch is this huge ranch that's actually, I'm not exaggerating when I say it's literally the state of Rhode Island. It's that big in size. So it's this huge ranch. Everyone knows about it in South Texas, and when I was at Exxon, we actually managed they were a lot of our royalty owners, so we had their whole genealogy known. Anyway, so he goes up and he says, my name is Dick Claybear. He goes, oh, Mr. Claybear, how you doing today, Mr. Claybear? And Mr. Clayberg said, well, I'm doing fine. And Boudreaux says, oh, Mr. Claybear, we just the same. He says, me, I'm doing fine, too. He says, let me ask you a question, Mr. Claybear. What you do for a living? Dick Clayberg says, well, I own a large ranch in South Texas. And Boudreaux says, oh, Mr. Claybear, we just the same. Me, I own a large ranch in Louisiana. He said, let me ask you something, Mr. Claybear. How big is your ranch? And so Mr. Clayberg said, well, let me put it to you this way. If you got in your truck in the morning and you drove all day, by the time the sun was setting, you still would not be all the way through my property. And Boudreaux says, oh, Mr. Claybear, we just the same. Me, I got the same kind of truck. Well, I'm so glad y'all enjoy my jokes. Okay, so let's look at the agenda then for today. We'll start with a brief review of chaining title, and then I'll give you an overview of the steps, and then we'll go through the actual steps to running title, and then I'll walk you through the final notes. So by the end of this, I want you to understand the process that a landman goes through in order to lease minerals. You can't just look it up in a book somewhere and there's all your answers. You actually have to do research on this stuff. So let's then look at a review of chaining title. Well, the first thing you need to understand is how important recordation is. Now remember we said that we said that in order to be binding against third parties, it's got to be recorded in the county courthouse where the property is located, not where the person lives, but where the property is located. So I thought it would be helpful for you to understand how you actually record these instruments. And one way is to go directly to the county courthouse where the county seat is located, and you would then go up to the county clerk's office, and you would then have your executed piece of paper. Let's say it's an oil and gas lease, and you would actually physically hand it to the county clerk, and the county clerk would charge you like I think it's $5 for the first page. I think in Midland it's $5 for the first page, and then $4 for every page thereafter. So there is a fee. It's not free, but at the same time, it's not that expensive either. So then she will date stamp it. She will date stamp that, and then she'll stamp it with a volume and page stamp. Now some, like Midland is uses volume and page, but some states use like a folio number, or there's another number anyway that they assign to each instrument that comes into the county courthouse for recordation. Then she would stamp that, and then she would give you the original back. She's going to make a copy of it, and she's going to include that in her, now that they're filing it digitally. So that's going to be scanned. And so that is how you record an instrument. It really is that simple. A lot of companies will send a check. You can also do it through the mail, where you just send a check to the county courthouse, and you ask them that this be recorded in the county records of Midland County, Texas, for example. So that is really all it is. It's very simple. You're handing a document to her. She's putting the file date on it. She's putting a file number on there, and then she's actually putting it in the county records. You, meanwhile, have your original lease back and can show that you are the leasehold owner. And put that in your system, and when you put it in your system, what the lease analyst does is she's going to put that volume and page number in the cross-reference section of the page. So that really is how simple recording the instrument is. Okay, let's look then at running the chain of title. So this is what the chain of title is. This is what's being recorded, is the ownership records. So it's literally, if the first person that owned it is the United States government and they gave it to person A, then person A would then convey it to person B. In each of these cases, these are links, okay? And the whole chain is just the historical series of instruments that were filed that affect that property. So it typically starts with what we call letters patent. Now a patent is, if you think about it like Shark Tank, I don't know if any of you watch that, but you think about, they always say, do you have a patent for it? Now, patent is, as we all know, a government grant, and it's given to an inventor, and it gives that inventor the right to exclude others from making, using, or selling that invention. You have a patent on it. You have the exclusive right to use it. In the United States, when they first gave the first title instrument to the new owner, they called that letters patent. And it's similar to the definition of an invention, but you are the only owner. Only you have the right to use that land, lease that land, mortgage that land, sell that land, whatever you want to do with that land. So it's uniquely yours, just like a patent would be uniquely for an inventor for a given invention. Okay. Now, this is also known as a homestead, this first conveyance, but we'll refer to it as letters patent. Now this is an actual letters patent that my grandmother had, and it dates back to, 1893. Now this was my grandmother's grandfather, so my great-grandfather. And you can see that it's got homestead certificate, and here's the number, what the application is. And so this is the first instrument from the United States government to my great-grandfather. And it says, whereas there has been deposited in the General Land Office of the United States a certificate of the Register of the Land Office at New Orleans, Louisiana, whereby it appears that pursuant to the Act of Congress signed May 20th, 1862, to secure homesteads to actual letters on the public domain, and the Act supplemental thereto, the claim of William Stoddard, this is my great-grandfather, has been established and duly consummated in conformity to law for the, and here it gives the property description, the northeast quarter of the southeast quarter and the southeast quarter of the northeast quarter of Section 8 and the south half of the northwest quarter of Section 9 in Township 8, South Range 2, west of Louisiana Meridian, in Louisiana, containing 160 acres and 13/100ths of an acre. All right, so then it says, now know ye that there is therefore granted by the United States to the said William Stoddard the tract of land above described, having to hold the said tract of land with all the appurtenances, that means with all the minerals. And then it goes on to say, in testimony whereof I, Grover Cleveland, President of the United States of America, have caused these letters to be made patent. And the seal of the General Land Office is to hereunto affirmed. Given under my hand at the city of Washington, the 23rd day of August in the year of our Lord, 1893, and of the independence of the United States, the 118th. So here's the signature by the President. I don't actually know if that's the actual signature of the President or if someone was just authorized to do that. But there it is. And then here's the volume and page number. So volume 9, page 344. So one of the earliest records in this place in New Orleans, Louisiana. So I just wanted you to see what this letters patent looks like. Now this is what was given to the landowner. In the county records, what you're going to see is someone's going to actually type out every word that's on this letters patent. So there won't be a signed original in the county records because they couldn't just make a copy of this because they didn't have copiers back then. So someone would actually have to physically retype the whole instrument so that the letters patent in the county courthouse does not look like this. This is why it's really so cool that my grandmother had this, because it's very hard to find unless you were the actual original owner. Okay, so I just wanted you to be familiar with what we're talking about when we're talking about letters patent. A lot of times you'll also hear someone say chain title all the way back to the sovereign. Well, the sovereign is the United States government. So that means trace it all the way back to letters patent when the United States gave it to the first private citizen. So that's what letters patent is. Now, just to make this more interesting, you see that he owned what's called fee simple absolute. That is, he owned the surface and all the minerals. So there is a kind of estate in land. That is, remember we talked about real estate. That's what real property is. But there is also, the owner of the property has the right to do what he wants with the property. And one of his rights is that he can segregate out the surface from the minerals. So he might sell the surface to someone else and maintain the minerals. So now you've got two additional estates. This is known as a split estate, S-P-L-I-T. That doesn't look like split. Split estates, and this is known as the surface estate, and this is the mineral estate. Okay, so a different person can own the surface than the mineral. So that makes it very interesting. So the surface estate, that's basically what you can see. Now the surface can be farmed, it can be ranched, it can be subdivided, it can be used for recreation. The mineral estate is all of the property below the surface. It includes oil and gas, but also things like sulfur, uranium, coal, copper, etc. So if you own the minerals, you have the right to all those minerals, and if you own the surface, you only have the right to use the surface. Now, the surface estate does include the water rights. So if there's water below the surface, that's deemed to be belonging to the surface owner. Why? Because water is not a mineral. So the court made that distinction, that water, underground aquifers belong to the surface owner. So sometimes if you need a lot of water, you are going to be negotiating with that surface owner. Now, here's what, so if you have one person owning the surface and one person owning the minerals, who do you take the oil and gas lease from? Well, because you want to drill for minerals, you take that from the mineral owner, okay? Do you also have to get permission from the surface owner to drill on that property? And the answer is legally no. And here's why. There's a principle in oil and gas law that says that the mineral estate is dominant to the surface estate. So you can have ownership by different parties. One person owns the surface, one person owns the minerals, but the mineral estate is the dominant estate. So if there's a conflict between what the surface owner wants and what the mineral owner wants, tie goes to the mineral owner because that mineral estate is dominant. So we do not have to get permission from the surface owner to lease from the mineral owner, because what would happen, well, if you think about it, and this is the state's interest in it, is that if you had to get permission from the surface owner, who's not going to get any royalty, but he is going to get his land torn up, what's the likelihood that that surface owner is going to say, yeah, you can pay me a little bit, and they get all the royalties and all the bonuses, that's fine, that doesn't bother me at all? Well, yeah, that would be a bone of contention. And so there would be a conflict between what the surface owner wanted and what the mineral owner wanted. And in that case, the tie goes to the mineral owner. Now, this, as you can imagine, causes lots of headaches, especially if the surface owner owns no minerals. Technically, when a well is set up, all we really owe is damages for growing crops. It's been a courtesy that we pay the surface owner. So we do pay the surface owner something, right? Even though legally we can say the mineral estate is the dominant estate. And so why do we do that? Why do we pay someone that we don't have to legally pay? And the answer is it's because of PR. And it's because you're going to have an ongoing relationship with this surface owner. And if the surface owner doesn't like the oil and gas company, they're going to sick their dogs on them. They're going to meet them at the gate with guns. They're going to make it very, very difficult for the oil and gas company to get their work done. And so we will go to the surface owner and say, look, we don't have to pay you anything under the law, but we'd like to give you something for your inconvenience. And you can then negotiate with that surface owner. Now, if they say, I want $1 million, and your company's not prepared to pay $1 million, then you can just walk away. But the bottom line is you say to the surface owner, look, the law says that we can do this to your land. So you're either going to let us pay you to do it, or you don't let us pay us. But either way, it's going to be, your surface is going to be torn up. So one of the reasons that we pay the surface owner, as I said, is for PR purposes. And that is, we don't want the little old lady going on 60 Minutes and saying, to Anderson Cooper, look what they did to my property, and they didn't pay me anything. They didn't pay me one thing, and look at all this damage they've done. And so then Anderson Cooper will go to the president of the oil and gas company, who will explain, well, you see, Anderson, under oil and gas law, the mineral estate is dominant to the surface estate, and therefore we don't have to pay any rights to the surface owner. What's most of America going to think? There's those big bad oil companies taking advantage of those little old ladies, right? So we want to, from a PR perspective, we do negotiate with this surface owner. Now, you also have to know the laws of the state where you're operating, because there are certain states like Oklahoma that does have a Surface Damages Act, a statute in the law. And in that case, you do need to negotiate under law in Oklahoma to the surface owner. But it's also been held in the courts that the surface owner cannot hold you hostage. So as long as you make a reasonable offer to the surface owner, if they, say they don't want it in favor of, they want a bigger amount, as long as you can prove that you were reasonable, the court will, say that you were in compliance with the statute. Okay, so just keep that in mind. All right, so now we got the dominant mineral state, surface minerals conflict, tie goes to the mineral owner. Now, so let's look at actually the chaining of title. I'm going to give you an example of how this works. So let's say this is my great-grandfather, all right, and this is my grandmother here. And let's say that he dies and he leaves all his property either by will, or if he dies without a will by intestate laws, or the laws of descent and distribution. So he dies, his 4 kids each get 25%. They own fee simple, that means they own the surface and the minerals. So Peter owns 25% of the surface and minerals, Luke owns 25% of the surface and minerals, John 25% surface and minerals, Laura 25% surface and minerals. But let's say that Peter then conveys to Reagan a full fee simple interest. Reagan then conveys to Bush, Bush then conveys to Lincoln, and then Lincoln conveys to Kennedy. Okay, Luke also sold his surface and minerals to Ford, and then to Ike, and then to Washington. So at this point in time, the chain of title would be Kennedy 25%, Washington 25%, John 25%, Laura 25%. So we started off with this letters patent. Now we're going to either see the names of these 4 people, either through a will or an affidavit of heirship, and then we'll start seeing these people convey their fractional interest. So let's look at how this can go if Peter conveys the surface to one party and the minerals to another. So in this case, Peter owns 25%. He gives the surface to Kennedy, and then he gives the minerals to Carter and then to Reagan. Okay? So Carter gets a half, Reagan gets a half. 12.5 times 2 is 25%. Now then, so Carter then takes his half interest, or this 12.5%, and he conveys it to Clinton. Now Clinton owns 6.25%, and he gives the remaining 6.25% to Jefferson. So now the interest is Carter 12.5%, Clinton 6.25%, and Jefferson 6.25%. Then let's say he conveyed the other half to Reagan. So Reagan now has 12.5%. And then Bush conveys half to Bush. And then Bush keeps half of his half, but conveys the balance to Lincoln. So Lincoln now owns a 3.125. Bush owns a 3.125 plus his another 3.125, the remaining half. And then Reagan owns, or did own 12.5%. So now the mineral ownership is going to go Jefferson 6.25%, Lincoln 3.12%, Bush 6.25%, and then Reagan keeping the other 6.25%. I think when I originally did this, I had somebody reserving their half interest, but I can't remember how I did that. But this would be then 6.25%. I guess if Bush conveyed his half and kept half, then he would have a 3.12, and then Bush would have a 3.12. That's what it is. 3.12. So that's their 6.25. And then Reagan would have the 12.5%. So then the ownership would be Jefferson 6.25%, Clinton 6.25%, Bush 6.25%. He conveys half of his 6.25% to Lincoln. So now he owns a 3.12. Lincoln owns a 3.12, and Reagan owns the remaining 6.25%. Okay, because he would only get half. Okay, so you kind of see how complicated this can get. So the way brokers do this is they, keep what's called a run sheet. And so this would be the ultimate interest. The surface would be Kennedy 25%, Luke 25%, for the surface, John 25%, Laura 25%. And then for the minerals, we've got Clinton with a 6.25, Jefferson with a 6.25, Bush with a 6.25, Lincoln with a 6.25, and then the remaining going to Luke, John, and Laura. So that is a chain of title example. And that is just how complicated it can get. So you're having to trace all of these instruments that occurred from conveyances from William. So now let's look at the process of leasing. Oh, by the way, this is also what happens in a title opinion. In a title opinion, the attorney is going through the same process to figure out who owns the surface and who owns the minerals. Okay, so now let's look at a basic overview of how this whole process looks. So how do you identify lands to be researched to determine the mineral ownership? Well, it starts with geology. Now, you may recall that geology determines that there is a play where oil and gas can be found. And a play is described as it's a reservoir that's geologically similar, or oil fields that are geologically similar. That is, they have the same source, they're in the same reservoir, they have the same trap characteristics, and the play is going to determine how large the area is to consider for lease acquisitions. So that's what a play is. So geology identifies a play, and the way they do that is they use different kinds of tools. They look at data from previous wells. They look at any seismic work that they may have. Maybe they shot seismic on the land. They look at any well logs in the area and any prior geological maps used to explore for hydrocarbons. Now, before we had these kind of sophisticated tools, we had early explorers were called wildcatters, and they would actually go out and look for oil and gas seeps. You might remember that from your History of Oil video last month, in that, you know, they could actually go onto the land and see gas escaping. So that's how they knew that there was gas under Spindletop, oil and gas under Spindletop. Now, once all the work is done and geology identifies the prospect, then the geologist is going to get a plat or a land map showing the section, township, and range to be leased. And going to say, you know, okay, Mr. Landman, here, go out and check the status of the minerals to see if anything is quote-unquote open of record. Open of record just means it's unleased. So go find out what's open of record. So this is what the landman is usually given. They're given, you know, okay, this is where we think the play is. In other words, this is where we think the reservoir is. So go and lease everything that's open of record. Now, this might be a company map. And a company map, this will show everything that is leased. At Exxon, we used this bright color yellow. So everything that was unleased, we could see from this map. Now, it may have gotten leased between the time this map was created. But so what the landman is going to do is he's going to go out to the county courthouse where this property is located, and he is going to then find out in this southwest quarter, you know, if that is open of record. Same thing here. See if all of this is open of record. So he's going to go be counting their, going to the county courthouse to determine this. But we got a problem. And the problem is that when you take a document to record it with the county clerk, they are typically recording that under the name of the transferee and the transferor. That's called the reverse index. So the direct index is the transferor conveys property to the transferee. So the transferor's name is how you look up the conveyance alphabetically. So under that land, that person's name alphabetically is going to be every instrument that they've ever been a part of. Then they have what's called the reverse index. That's based on the transferee's name. So if you don't know who sold the interest to the mineral owner, but you know who currently owns it, then you can go to this reverse index, look it up by transferee, and then that's how you'll determine, that's how it is filed. So it's filed chronologically, first alphabetically by transferor or transferee, and then chronologically. So if you look up your name and you're on a deed, under your name will be every deed that you've ever signed. Okay? So when geology gives us this map, we don't know who the landowners are, so we can't use this direct grantee-grantor index, and we can't use the reverse either because we don't know who the current owner is. So we don't know who the past owner is, we don't know who the current owner is, so now we've got to lease this property. How are we going to do it? So you have public record, it's filed by the grantor's name chronologically and then by the grantee's name chronologically. How are we going to locate the property? How are we going to locate the owner from this deed? And the answer is you go to what's called an abstract company. Now, sometimes it's called an abstract plant. And what they do is these people actually, they really saved our lives in the oil and gas industry. But what they do is they go to the county courthouse every day and they take every single instrument that's filed of record, they make a copy of it, and they bring it back to their abstract plant or their abstract company, and they file that instrument by property description. So you can go to the abstract company and you can look up the property description that you want, and they will have every instrument that affects that given piece of property. So that's pretty cool, right? And that's awfully nice of them, right? Well, they charge. They charge because, you know, that's a pretty nice service they're providing. So you can either stay in that abstract company and do all your running title, and they're going to charge you an hourly rate. Let's say it's $200 an hour, which is going to cost your company quite a bit of money. Or you can just write down the volume and page numbers of every instrument in that legal description. So this is what the abstract of titles is going to look like, okay? This is what the abstract company is going to have in their records, and behind this abstract is every single instrument that ever affected this property. So here you see, this is all description. This is a quitclaim deed dated July 29th. That's 1893, and it's in volume 1, page 3. And that's LP Hardiman to CC Harwell. So what they're giving you is every instrument in this property description, and all you really need to do is write down what's on this index. That way you'll get in and out of the abstract plant very quickly, and you won't have to waste a lot of your company's money. Now, when we do a title opinion, what we do is we go to the abstract company and we say, okay, we want a copy of every instrument that's in this chain of title for this given property. And they will do that for you. And the advantage is that the attorney then doesn't have to, you don't have to pay the attorney to come out to the county courthouse, stand there, wait for the books to be available, and then draft his opinion. You actually give this, you know, abstract of title is what it's called, to the title attorney. Now, these are expensive. I've seen them go from $10,000 to $20,000 because all the work is really done. Every instrument is in there. But for most landmen, you know, their company is not going to allow them hours and hours of time to stay in the abstract company, nor are they going to pay $10,000 for them to run the chain of title. So what the landman does is they do what's called a run sheet. Oh, I get to this here. Okay. All right, so coming up on a run sheet, I'm going to come back to this in step 4. So I want now to walk you through the process that a landman would go through to lease a given piece of property. Well, he would start by preparing, and that is he would research his properties. A lot of companies have a software called Dwight's PI, Dwight's Petroleum Information, and Dwight has every well that has been given a well permit by whatever the state regulatory commission is, the Railroad Commission in Texas. And there's a way you can look up the well, and it will show you whether the well is producing, how much it's producing, what it's producing. So the first thing we do is we'll, check Dwight's to see if there's any wells out there. And then we'll look at Dwight's and say, well, is there production? Is it still production? Is it still producing? And then we'll look into our company and say, hey, do we have any old land maps on this? Because maybe we have the owner's name on there. And then we could also get state production reports from the state of Texas. So that's the preparation you want to do before you head out. Then you head to the county seat where the land is located. This is Monahans County, seat of Ward County. And then from there, you will do it, and all I did here was do a Google search to say, okay, abstract company or county seat of, whatever city this is. So you head to the county seat where land is located. Now, by the way, a lot of times the company landman will not be the one going out physically to the company. The company landman will usually supervise what we call brokers. And brokers are independent landmen that usually live in the area. And we hire them to go and research the county records. And there's a couple of reasons for that. One is, especially for a big company like Exxon, we don't want word to get out that Exxon's looking at leases. They're trying to lease in Monahans County courthouse. And then people who have done no research, who have no geologists on staff, all of a sudden all they hear is Exxon is leasing there, and they start buying up leases. So there'll be like a leasing frenzy. So Exxon always tries to keep its brokers undercover, especially in a hot area. So they won't send their company landman with their Exxon logo on anything. They'll hire someone out in the field. And the field landman has a couple of advantages. One is that he probably knows the county clerk. He probably knows these people that work in the county courthouse. So if he's got good people skills, he's going to have great success in getting what he needs. And it keeps it confidential. So nobody knows who in that county courthouse is working for Exxon or who's working for any other company. Now, remember I said that this gets a little tricky because you've got to be the first person to record the instrument. So the instrument is actually recorded as with the broker's name on it. So the lessor is the mineral owner's name, and the lessee is going to be the name of that broker. Again, we don't want to expose the fact that that company is working for us. And so the broker will take the leases in the name of his own company, and then at a certain point in time, he will assign all those leases to Exxon. There'll be a huge assignment listing all the volume and pages where these properties are located, and then they will then transfer that to Exxon once they've leased everything that they want to lease, and there's no risk that someone's going to find out, who they are and take up all of our leases. So a broker is usually the one that's going to head to the county seat where the title is located. And all I did to find, then we're going to go to the abstract company. And all I did was look up Pioneer Ward County Abstract Company in Monahans, Texas. Now, the landman, if it's a field landman or a broker, he may already have a good relationship with an abstract company. And so he may be able to go to that abstract company and get, what he needs. But, just, if you don't know, just look it up on the internet and then, call them and ask them how their records are organized. So this is what you're going to get when you go to the abstract of title. You're going to have this index on top of every single document that's ever affected this property is going to be behind this index. So this is huge because it gives us the volume and page number. Where is it? Volume here, page here. Volume 1, page 3. So then we can go and actually pull those instruments. Now, rather than have the landman stand in the abstract plant and run these, look at this chain of title, what they will usually do is they will do what's called a run sheet. And a run sheet is basically, now the term is broadly used, so different landmen are going to use the term run sheet differently. But in this case, what I would typically do is I would go to the county courthouse and I would take this abstract of title, from the abstract plan, I would take the abstract of title and I would just list everything it has here. I would list the name of the grantor, the name of the grantee, which is all right here, and I would list the volume and page, that's here, 133, and then I would do the instrument date. I'm writing all this down directly from this one piece of paper, this one index, because I know this index summarizes the whole chain of title. Every legal everything that happened on this property in every conveyance is now indexed by this abstract company. So I'm going to take about an hour, and I'm going to go through and get the abstract and write my run sheet out. And all I'm doing is writing what they have here, okay? And so from there, I'm going to go and start doing what we call pulling books. And when you pull books, all you're doing is let me see if I have a picture of that. When you're pulling books, you are literally going into the county courthouse, and they have a series of land records. And it'll say what the volume land record is. So let's say it's volume 1, and then it's page 3. So you pull the book, this big, huge, heavy book, and it's made of like steel on both sides. It's like a big notebook, but it's steel on both sides, and it has a kind of a complicated interlocking system that keeps all the books in place. But that's where they are. And so then you would just go and literally pull that book. That's why they call it pulling books. Open the book to that page and then start taking notes on whatever instrument is on that page. So we know that the first instrument is going to be a quitclaim deed. And so then we start chaining title from that point on. So that is what's called making a run sheet and pulling the books. Now, the issue, though, is when you're a broker, and let's say this is a hot area, there's a lot of other landmen in the same county courthouse that are also pulling the books. So sometimes you have to wait for someone to finish reading the instrument, taking their notes, before you can even get the volume, before you can even pull the book, because someone else uses it. That's another reason we give the title attorney an abstract, because we don't want them wasting their time. You know, the clock ticks for them charging us however much they're charging us while they're sitting around the courthouse and waiting for the books to become available. So it can be kind of a frenzied situation, especially in a hot area, because everyone's trying to pull the same books if they're interested in the same area. So here we're going to look at an example of what you look like when you, or what you do when you actually pull a book. So this is volume 2146, page 230, and the instrument's dated April 1st, 03, and it's recorded 4903, and then I put a check mark showing this is from the same person here. And then this is the new owner, is Permian South 40 Partners. All right, so I'm going to go to the county courthouse. I'm going to pull the book 2146, and I'm going to flip to page 230, and this is what I'm going to see. I'm going to actually see this warranty deed. Now, what the landman then does from here is they have to read this warranty deed. They have to read it word for word to make sure there's nothing sneaky in there. So what he's going to read is that Charles Stow and wife Chandra Stow, whose address is this, and he's reading it word for word. I'm going to skim it. Conveyed, and by these presents does grant and convey into Permian South 40 Partners all of grantor's right, title, and interest in and to the surface only. Okay? So if you're a landman and you're in a hurry, you might think that this Permian South owns part of the minerals, because it says grant, convey unto Permian South all of grantor's right, title, and interest. So if you just read that, you're going to presume that Permian South now owns 3.48 acres in this area and a 69.73 acres in this area. That's why you have to read it so carefully, because they don't own any minerals. So if you go and try to take a lease from this surface owner, then you don't have a valid lease. You can't take a lease from someone that doesn't actually own. So that's why they're reading it very carefully. Now what they're looking for is, first of all, they want to make sure that it's recorded. Well, obviously it would be, but make sure that the volume and page matches what's on his run sheet. Then it's got to have a grantor. That's going to be Charles Stow and Chandra Stow. It's got to have a grantee. That's Permian South 40 Partners. And it's got to have consideration. So consideration is what makes a contract binding. And usually it's a dollar amount. So it's what makes it's what makes a contract enforceable, because both parties are giving up something. So in this case, Charles Stow and Chandra Stow are giving up the surface, and Permian South is giving up money. Now, what we usually see in a lease or in a warranty deed like this is something like this: $10 and other good and valuable consideration in hand paid, or $1 in hand paid, or $1 in OVC, which stands for other valuable consideration. And the reason we don't put the actual dollar amount here for leasing purposes, for one, is that the actual consideration would be the bonus paid. So we don't want everyone to know what the bonus was. So we just put a dollar amount in here: $10, $1, $100, whatever it is. The court doesn't care what the consideration was. All they care about is that there was consideration. So when there's a sale of a house, they're not going to have that. They might do it for a sale of a house, but for a lease or a warranty deed like this, or anything that the new owner wants to keep confidential, they're just going to put in a sum. Okay, and then we've got the granting clause, and what that says, the word grant. And by these presents does grant, convey unto Permian South. And then you got to have the legal description, that's here. It's got to be executed, that means it's got to be signed. Remember the statute of frauds? And it's got to be acknowledged. Okay, acknowledgement means that it goes before a notary public, and the notary public swears that the person who signed the instrument is who they say they are. So I need to go through all of those steps. If something is missing, then I've got a cloud on title. So if I'm the attorney and I notice something is missing, I'm going to make a note of that, and I'm going to have them go out and secure whatever affidavit is going to prove up what the issue is. So if it's an inaccurate legal description, I'm going to ask that there be a new warranty deed filed of record with the legal description corrected, or a corrected warranty deed, or a corrected lease deed. If it's not executed, that's a huge red flag. That means you need to go get the person to sign it. And if it's not acknowledged, you need to secure an acknowledgement from the owner, if at all possible. So those are kind of the red flags that an attorney is looking for to see if there is any clouds on title or any defects. Does this warranty deed do what it says? Does it actually convey whatever interest it says legally? And to do that, you make sure it meets these elements. Now, one big issue when we're looking at warranty deeds that a landman really has to understand is there's a difference between whether minerals are conveyed or whether a royalty is conveyed. Now, this gets really complicated because we know we have a royalty interest on our oil and gas lease. That's not what this is referring to. This is referring to what we call a non-participating royalty interest. And the way that works is that you have someone that owns fee simple. Can y'all see this writing? Raise your hand if you can see this writing. Good. Whew. Sometimes you can't read it. Okay. So what happens is you have, let's say, I own minerals, okay, and I own surface and minerals, all right? So I want to convey the minerals to person B, but I want to keep a little bit of the profit, okay? So I want to keep, if there's ever any royalty on this property, I want a percent of that royalty. So I want a 1/8 royalty interest. Now, B owns the minerals because all the minerals were conveyed to B. So who am I going to take that lease from? I'm going to take it from B. Okay? Do I take it from A? No, because A doesn't own the minerals. Okay? So B is who I want to take it from. And all this is saying is A is saying, look, B, if you ever sign a lease, let's say for a 3/16 royalty, I'm going to get it 1/8 and you're going to get the other 1/8. But let me keep just a little bit of the profits. Okay, but A no longer owns the mineral, so you would not have A sign a lease. He does not have the executive right. But what's being conveyed in this conveyance is, this conveyance here is a transfer to B of all the minerals, reserving 1/8 royalty interest. And this is what's called the non-participating royalty interest. So you have to see, now if A wanted to sell this interest, A would sell to C a 1/8 royalty interest, okay? And so C would then own a non-participating royalty interest. Okay, this becomes very important when we're about to drill, and that's kind of where the pooling comes in. But we'll talk about that next time. So when you read an instrument, you have to know the difference between, are they transferring minerals? And if it's minerals, they'll say oil and gas in or under. Okay, that means the property interest under the earth, and they will usually use the word minerals. But if they're only conveying this 1/8 royalty interest, not from the lease, but from, A reserved a little bit, it's going to say something like the right to receive production payment. So those are the some other buzzwords that they're going to use is minerals. It says oil and gas in or under. The fraction size is greater than 1/4. That's going to be a clue to you that that's a conveyance of minerals. So you're looking for key language in that warranty deed. Then you have a right to receive. So then the royalty, or the non-participating royalty, let's be clear about that. It's not the royalty in the lease. They have no executive rights. They have no right to lease any of the lease payments, not the bonus, not the royalties, or they do have a share of the royalties. They're known as the NPRO or NPRI. And what it says in the deed was oil and gas produced and saved. Not in or under, but produced and saved. That's a clue that they're conveying a royalty interest. Sometimes they'll say oil and gas produced, saved, in marketing. And if the fraction's less than 1/8, remember he kept a 1/8, so that's less than 1/4, that's another clue to you that royalty is being conveyed. Now when you're running the chain of title, you don't really pay attention to royalty interest, these non-participating royalty interests. All you care about is who do I take the lease from, and you take the lease from the mineral owner. So you might see language in an instrument that talks about this royalty interest, who owns the royalty interest. That's going to be left for the attorney to figure out. The attorney's going to figure out what this non-participating royalty interest owner's interest is. All you care about when you're running the chain of title is who owns the minerals. So very important distinction between the minerals and a non-participating royalty interest. Now step 6, when we interpret the instruments, if we're dealing with fractions, just a couple of hints here. If it says 1/2 of my 1/4 interest, that means you multiply 1/2 times 1/4, or 0.50 times 0.25 equal a 0.125. So half of 50 is 25, or 12.5% mineral interest. If it says out of, then it means subtraction. So 1/4 out of my 1/2 means 1/4 minus 1/2. That would be 0.25 minus a half, which is going to be 1.25. Did I get this right? This is wrong. Oh, Lordy. So you're going to go 0.125. You're going to go 0.5 minus 0.25. Minus 0.25 is going to be 0.25. Oh, that does work out. Okay, now then we go to the chain of title. So the next thing is a lot of people then chain out their title. Once they've looked at all the instruments, they're going to say, set up this spreadsheet that's going to have the type of deed, who the assigner was, who their assignee was, conveyed, reserved. So that's how you chain title. And then what the company wants is what's called a mineral title chain. They want something called an ownership report. And the ownership report just shows, I'll have to put one of those out on the website. It just shows who the surface owner is and who the mineral owner is, or mineral owners are, and their percentage of interest. That way you can give that to the company landman that you're reporting to, and the landman can say, okay, go ahead and lease. So now we know, landman doesn't want to look at all this. They just want to know what the bottom line is. So that's what's called an ownership report. So you prepare that ownership report. Sometimes it's in this form. Sometimes it's in a, I don't like it when it's in this form. It's, there's still a lot of reading to do. I like it when it just says surface is this, minerals is this. And then from that point, then you go and contact the mineral owner and you start negotiating the lease. So that's step 10 in the process. So let's look at the full 10 steps that a landman goes through to chain title. He starts off by preparing. That means he looks at any resources he has in-house. So he'll look at Dwight's PI if it's available. He'll look at state production reports of any wells producing in the area. He'll look at old land maps. And once he has that, he'll either go to the county seat or hire a broker to go to the county seat. And the county seat, the broker will then determine where the abstract company is. So the abstract company, he would then go and pull that index and write down all the volume and page using what's called a run sheet. There's lots of different forms of run sheets out there. This is just one example. But then he will take that run sheet, which shows the volume and page of every instrument, and he goes to the county courthouse and he starts pulling books. So he pulls whatever volume it says and turns to that page number and then starts interpreting that instrument to make sure it's got all the elements of a valid contract, grantor, grantee, consideration, executed, acknowledged, and look for, are they conveying a mineral interest, are they conveying a royalty interest, or are they conveying a surface interest? And then he'll write out his chain of title report. Now, the next thing he'll do is he'll identify any gaps in title. I guess I skipped this. Okay, so sometimes there'll be what's called a stranger to title. And what'll happen is you'll see a deed from Lincoln to Carter, and the next deed in the chain of title is from Clinton to Reagan. So you say to yourself, where did Clinton get this interest? I mean, it doesn't look like it was conveyed from Carter. So Clinton then becomes a stranger to title. And that means you have to go identify those gaps, and you have to go to the probate records to say, well, maybe he died and he left it to him that way. Maybe it was a divorce situation, or maybe Clinton got it because it was the property he didn't pay, whoever the owner is didn't pay their property taxes, and so it was sold at a sheriff sale, and that's how Clinton got its interest. But basically you're going to all these other records to see if you can figure out where Clinton got his interest. And so that's called gaps in title or strangers to title. This is where a lot of your title opinion clouds on title will come from. That's a cloud on title. When you have a brand new person and you don't know where he came from, there's a deed in there, but we never show how Carter conveyed it to Clinton. Gaps in title. And then we prepare our ownership report, showing who the surface owner is and who the mineral owner is, and then we actually go out and contact the mineral owner and begin the negotiation process. So what we gave you was a review of real property law. We talked about surface ownership and mineral ownership, and then we talked about how the dominant estate, the mineral estate, is the dominant estate. And then we talked about the steps to running title, including going to the abstract company and writing down their index. We talked about the problems of filing only by the transferor and transferee, and that the abstract company saved our lives. And we also noted that the attorney can be given an abstract of title, which is the complete title for that given property. Very expensive to do so, but if your attorney's charging you by the hour, it might still save you money. And then wrapped up with any final notes. Does anybody have any questions about running the chain of title? Feel free to raise your hand. Yes, okay, I'm getting a question. This is for Texas, okay? Some states may actually have it indexed out by property description. Texas does not. I'm not sure whether Oklahoma does or not. I think they don't. Does anybody know? So this can vary from state to state, but what stays the same is you're pulling the volume and page number. Okay, getting another question here. Yes, there are some brokers that will just go and check for leasehold. So in other words, they go to the county courthouse and all they want to see is there any lease in this chain of title? And if there's no lease, then he will go to the last owner that's on the index and go negotiate with that person. Now you run a risk there that, maybe that person is the surface owner, maybe that person is the mineral owner. But if it's a really hot area, sometimes the oil and gas company will say it's worth it to go ahead and pay a bonus to someone that doesn't really own it, because the draft bonus says we have 30 days to figure out if you actually own it. So better for us to go and get a lease from someone who doesn't really own it than risk waiting and being sure and then taking a lease and then failing to take that lease because we weren't 100% sure. So sometimes people will just do a leasehold check, just flip through the county records and look for any leases, and then from there they'll go out and lease the last owner of record. That's a bit risky, but you never know in a hot area. Okay, here's a question. Does the broker negotiate the lease and pay the bonus, or does the oil and gas company? Well, the oil and gas company pays the broker to go out and negotiate the lease, and the broker will have a check. The oil and gas company will give him a check for his bank account, and the check will show up. That draft will be in his name. So again, we're keeping that confidentiality. We're keeping that undercover. Any other questions? Okay, well, if there's no other questions, I thank you for your time, and I look forward to seeing you in the next webinar.